this part is really for panel discussion and hopefully friendly disagreement. But also if there are specific questions that you wanted to put to the whole panel for them to discuss. I have one that's been submitted in advance, and this is a technical question, but it is this. And this specifically relates to the Law Commission's proposals. So the Law Commission is recommending that all schedules to the Wildlife and Countryside Act 1981 are reviewed every 5 years, while appreciating the need for consistency, particularly with regard to Schedule 9 non-native species. The potential to create problems could some flexibility be built in. So, to sort of contextualise this question, what this basically means is every 5 years we will, there's a process through which you look at the law every 5 years. And effectively, and I am paraphrasing in a way that Keith may well object to, and effectively decide what things should be listed as having what level of protection. I think that's quite accurate. And it's looked at on this basis. The question in relation to flexibility, I guess, is should we look at these things more frequently and review the protection given to different species on a much greater basis, or is it better to have a rigid timetable that basically says, no, we'll do it for 5 years. I believe Mark wishes to go first.
No, I mean, I'd say you can do both in the sense that you can have a scheduled review, a scheduled general review of the schedules, if that makes sense, and that can be on whatever period you want to make it. But you have to build in a mechanism for reviewing something where you think that something has changed. And it's no good waiting 5 years if the species that you're concerned about is going to disappear from an area without some kind of, re-evaluation. So I would have thought that having a periodic schedule review is fine, but there has to be a mechanism surely built in so that a particular entry on the schedules can be reviewed at any time.
I think this one needs to be seen slightly in the context of the actual underlying prohibition. So Section 14 of the Wildlife and Countryside Act makes it an offence to release out of your control, release into the wild a species which is not normally resident in the in Great Britain. Now, that is the problem with that is that as soon as something becomes established in the wild, it comes outside the prohibition in Section 14. So, as soon as it establishes a self-sustaining population, releasing it annoyingly stops to be a criminal offence, and you need to schedule it. And this is because, for reasons known only to themselves, they used part of the tax code to establish the provision for non-native species. So you use ordinarily resident as opposed to the slightly better term we would suggest of a species or outside its natural range. If you change the Section 14 prohibition such that it is a criminal offence to release out of your control a species which is out with its natural range, then actually you put a lot less pressure on Schedule 9, and therefore you don't actually need to review it as often because its natural range in the same way doesn't change in the same way that it can establish, which is the problem with the current law, the current Section 14. Is that sort of clear? So part of this is informed by the fact that there's a problem with the inherent offence in England and Wales, which isn't the same offence in Scotland. On top of that, to require someone to conduct a review of a schedule every 5 years is not the same as saying they will only conduct it. So the power is available to the Secretary of State or Welsh ministers, as we propose it, at such a time as they would like to make use of it, and that would apply to all of the schedules capable of review. If they choose to use it to the backstop, well, that is their choice, but there is nothing to stop them exercising the power and the concurrent consultation. We did toy with the idea of an emergency listing type provision, i.e. that you had an emergency, you know, a species being wiped out or something like that, and therefore you wanted to list it very, very quickly. But it has dangers because it only becomes something new if you reduce the consultation button in it. And therefore you would then have a problem, because otherwise you must well use the existing power. And then we run into a collection of other problems, including the period for which that emergency listing should stay. Should it be to the end of the existing 5 years? How do you disturb it with the five-year timetable? So it would seem as better just to have a hard 5 year, but that doesn't deprive you of the power to use it in the 5 years. And in relation to Schedule 9 itself, we think that altering the underlying criminal offence would correct many of the problems and the burden placed on the current Schedule 9, which is due to the criminal offence being based around whether it is present and naturally occurring in the wild as opposed to what it's meant to be doing, which is protecting the species outside their natural range. Is that anywhere close to an answer?
That's beautifully technical.
You said it was a technical question.
It was a technical question. The question was raised whether, I'm not sure whether this is appropriate for this forum, and I thought, oh hell yeah. So yes, so thank you for that. Okay, are there any other, has anybody got any questions that they would like to put to the whole panel? Because otherwise I've got loads. Anybody? Yep.
Picking up on something Keith was talking about before the break, and that is the question of who enforces wildlife crime. I'd be interested in views from the panel on who should be enforcing wildlife crime. Because as I see it at the moment, nobody has that responsibility, and that is part of the problem about getting proper resources in that area.
I was going to pick up on that issue of whether or not it actually is the police, because I've written stuff that suggests it isn't. Not because they don't want to, but in fact, ACPO has said in the past, we are not mandated to do this, and we are not given resources to do it. So it is largely up to the individual chief constable as to whether or not they do it, not that ACPO as a body or the police service is unwilling. So yeah, if I can put that to you.
Shall I go first? I'll go first on that one then.
Yeah.
In an ideal world, who should it be? It should be the police in partnership with other expert agencies that have an interest, in the same way that the police try and deal with every other form of crime that they're mandated to look at. It should fall under the auspices of the police, but since the Crime and Disorder Act 1998, all agencies whose behaviour might affect the likelihood of more crime taking place, and all those who have got an interest within that area, including local authority, primary care trusts, health trusts, fire service, youth offending teams, young people harming animals, and obviously in this case relevant NGOs should be working in partnership and be focusing on doing more prevention activity, obviously as I've already said, which can also underpin enforcement. So I would say it should be a partnership approach, but in an ideal world that would include the police and local authorities first and foremost.
Anybody else?
Well, I was just going to say there is a bit of a difference now, of course, in Wales. And we don't hammer on about Wales all the time, but of course now that Natural Resources Wales has all the powers that the Environment Agency, the Countryside Commission and the Forestry Commission formally had, there is a certain amount of integration going on there, which potentially should make things a lot better, because at least the police have got now one policy rather than three, which they were like before, but they've still got all local authorities and everything else on top of that. So I mean, in that case, maybe things will be a bit easier in that part of the world, but it remains to be seen, because they've been going for less than years.
Yeah. You know I'm going to disagree with this. I disagree because it's a regulatory model. It is an offence to kill a bird unless you have a licence. So to deliberately kill, or it will be an offence to deliberately kill a bird unless you have a licence. At the moment, it's an offence to intentionally kill it. And we will skip over the infraction word that is at the moment. But it is an offence to kill a bird unless you have a licence. I do not think that the appropriate authority for the regulation of compliance with a licence is the police. This isn't because I don't think they want it. It's not necessarily because I don't think that they can do it. But it is a licence issued by Natural England which will contain a collection of technical data in relation to the operation or not of a wind farm or a railway. So track speeds, for instance, amongst other things. Actually, to be fair, on that point, the regulator theoretically wouldn't be the British Railway Police as opposed to the local constabulary. But anyway, I just don't think that that is the right way of seeing the world. It's the problem of having a single offence applied across, all of humanity.
Okay. Two members of the panel were scribbling furiously, so I don't know if they have something they want to say at that point, or before I throw in my follow-up question.
Yeah, no, I have something to say.
Okay, yeah.
Well, I think part of the reason why there's disagreement is because perhaps we have different understandings of what we're including in terms of wildlife crime, for a start. I think that this sort of idea that somebody has just breached a licence and therefore it is a regulatory offence is quite different to how other people might conceptualise what they mean by wildlife crime. And I think so some people take much broader understandings and some people take much narrower ones. But it would also question the fact that the police do get involved in enforcing when people breach licences, because they do it with liquor licensing and are involved in enforcement activity against licensees who serve underage people or outside their licensing conditions. So there is precedent for doing that, and I don't think that the existence of a licence means therefore that the police shouldn't be involved in that. I accept that in some circumstances you may want to go down the regulatory route and then it would be the licensing authority that would then follow that up, but I don't think that necessarily has to apply across wildlife crime.
I can see that, although you and I might disagree about the nature of the liquor licence and the licence to operate a wind farm, but I can see that.
So my follow-up question here would have then been, so given, notwithstanding everything that Mel said about problems of defining wildlife crime, I think you raised in one of your questions, depending on who you ask, wildlife crime means different things. So there is no single definition of what wildlife crime is. So do we then need, I asked the whole panel, a definition of wildlife crime that distinguishes between wildlife crime as a licensing and a regulatory issue, and wildlife crime as a crime against a sentient species, which is, Mark used words similar to that, but a crime against a non-human animal, commensurate with a crime against a person, so that we are talking about two different things. One is a crime against a living being, which I would argue is a crime which is a criminal... Sorry, I'm supposed to be neutral. Which we could consider might be... Anybody who's read my book knows I'm not. But which we could consider as a crime that should be seen as a crime of violence or conflict against a sentient being. And that is absolutely a job for the police, or that is one perspective. And the second definition of wildlife crime, which deals with licensing or regulatory issues.
In some circumstances, the first of those, if you breach the second of the, if you breach your licence conditions, then you may be perpetrating a crime against, against a sentient being. That, so you kind of go from one into the other. I think there's two very practical reasons why it's good to have the police involved from our perspective. One is because of what, and I agree with you about partnerships, but having the police involved means that because these people are also likely to be committing a wide range of other offences, that you start to connect these offences. And we know that rural crime officers often identify people that are, hair coursing, but will actually arrest and the convictions will be related to other crimes that are currently deemed to be more serious or have more serious penalties associated with them. That might be theft or damage to property or whatever it is. The other reason is because if the police are involved, the crime is now recordable.
Yep.
In both of these cases, there's a dead bird, isn't there?
Sorry?
In both of these cases, there's a dead bird. There's two slight things about this, and this is something which came out of...
I've got badger examples, don't worry.
Yeah, no,
So,
okay, in both of these there is a dead animal of some form. We are going to assume for the purposes of this that it wasn't a trembling sea mat, although I think they should be, we feature, focus far too much on the cute. Trembling sea mats really are not cute. But, firstly, we're a little bit hamstrung here anyway, in a practical term, because the way the directives are constructed. You have to transpose the directives, you have to do it clearly. There isn't really the option within EU law to split in the way that you're saying it. But I don't necessarily think that's actually all of the problem. My worry here, this is something which came out very significantly when we were doing the Law Commission thing, was there's no regulated community. There is, when you talk about crime and people doing other crimes, that is completely true for a section of the people transgressing wildlife law, but it's not true in the same way for other communities who we also could care about when applying wildlife law. You could be businesses, but I don't take your point of view. Sometimes the business is also wholly illegal, or they are also transgressing. It just doesn't work. There is no community here. It's not all businesses. It's not all Danny the champion of the world. It's not anything actually, and that's the inherent problem. So I just don't know whether there is a slice and dice.
okay.
But then at the same time, traditionally, many harms are caused to people, and not all of them are criminalised, and not all of them are dealt with through the criminal law. So there is no reason to think that the same has to be the case. Can't be the case with animals either. I do have concerns about two-tier systems depending on where those tiers fall, but at the same time, you don't have to criminalise all harm to control it.
I'm confused by the whole system, because clearly Natural England and Natural Resources Wales have got the powers through civil sanctioning and through Wildlife and Countryside Act to investigate and prosecute wildlife crimes, and they've made statements that although they have those powers, they're not going to do so. The police have not been obligated to investigate wildlife crime, and actually we're in a position where some chief constables may say there are others who can do this, and we are not going to do so. And Mark advocates that it should be the police carrying out the investigations, and I certainly have sympathy with what you're saying in that they have a wider perspective about criminal behaviour. The converse side of that argument is that you then get investigators who are not experts at investigating bats or news cases.
But that's where the partnerships with expertise come in with you as well.
Yeah, and if that works, then that might affect that. But there is a growing reluctance in the police to work in close partnerships with NGOs for understandable reasons.
And yet the big society ethos would say that we all come together and NGOs and statutory agencies work together and no crime goes unpunished. And unicorns. Yes, I think that's true. I mean, is there then a perspective that, in fact, I think, as Haydn said in his presentation, he talked about the fact that some of the language that is being used in the better regulation agenda, which I've done some work on in the past, and in the red tape thing, is all about, it does use words like rolling back regulation, reducing the burden. I'm going to ask the panel whether you or not you think then that in fact wildlife crime is dealt with differently, or wildlife law is enforced differently, dependent on whether it's an individual offender who is very much seen as a criminal who is within agreement with the police, or whether it's I'm posing the question, or whether it's a corporation for whom then potentially the better regulation, Hampton and McCrory risk principles start coming into play.
Well, yes and no is the answer to that. I think in practice that has tended to be the case.
Yeah.
Though the recent messages that have been sent about the applicability of civil sanctions suggest the opposite. So I don't really know where the government stands on this. I think that one of the problems that we got with the current sort of messages coming about civil sanctions, where if it is the case that the government just wants to reserve these for large corporations, but they're on record as saying, that does seem to me to defeat the entire object in the first place. I mean, there are some individuals who are going to go out their way to commit very serious crimes, like happening in washers and so on. But if for companies and individual companies less than 250 people and individuals, the only sanction is going to be criminalisation, then I mean it comes back into what you're talking about. It doesn't work at many levels in any case, other than perhaps moralising the crime, as you say. But I think we have to have the option, particularly as some people can disturb or can even injure or take a bird sort of inadvertently in some circumstances. That's exactly what civil sanctions are for, and particularly, for instance, things like enforcement undertakings. You mentioned earlier on a situation where somebody disturbs some sparrows, and rather than criminalise them, they put them back. Well, enforcement undertakings and civil sanctions were designed specifically for that purpose. But if we're not going to allow them to be used by anything less than a corporation with 250 people in it, which frankly puts most corporations committing wildlife crime, I suspect, in the absence of statistics, but I wouldn't mind putting quite a bit of my salary on it, most of them completely outside the scope of those sanctions. And that seems to me to be, I don't know, they seem to have created something for a valid purpose after a great deal of effort. I mean, Philip Hampton and Richard McCrory spent, many years of their life putting this stuff together, and neither of them are idiots, I met them both. It seems like a hell of a waste of time if the government's going to throw it out, for reasons that I personally think have everything to do with currying favour with industry and nothing to do with protecting the environment. He said,
Pete, so it's something that you've talked about before with respect. We used the example of the batteries that were destroyed by a small-scale developer, and I think you've said in the past that this may be the case. I'm sure you can find examples where this isn't the case, but in some ways it's more likely to be a small-scale developer that's going to commit that kind of crime, because for a large corporation, first of all, the cost of compliance is relatively much smaller proportion of the costs of the process as a whole. Secondly, there's reputation risk to large corporations, which may actually be a much greater consideration for them than some smaller companies. So I mean, you've got you've almost got a situation where your smaller operators are more likely to take the risk of committing a crime in order to save the cost of compliance.
Yeah. Well, and again, I think it was you that put up the examples of just what the difference is between committing a crime and making a fat load of money from foreign ivory on the internet, and going to get not that bothered about a criminal record anyway, a few hundred quid, back out, carry on. Whereas if there was some enforcement undertaking, I can't imagine what it would be in that case, which reflected the severity of what they'd done. I suspect that might be taken on more seriously. Or whether it would deter them, I agree, it's another question. It might incapacitate them for a while, economically, if not physically.
Some quite nice sort of other examples in this area, which I quite like, the sort of administrative sanctions model, which is Fender guitars, who were found to be importing wood in countries to a collection of international treaties, and now have to account for every piece of wood that they import into the US, with the additional burden of which is significant, but it's both a marker and it's a burden. It's a very interesting way of sanctioning something. We actually in part do this, but we don't do it always for the sort of people, for developers, because if you are convicted of a wildlife crime, where wildlife crime is defined reasonably broadly, you can't rely on a general licence. You're not put into the nice bit of the world which says we don't care about these species, particularly providing you authorise a person, you can go off and do these things. But the people who cannot use those licences are anyone who has been convicted of a wildlife crime. So everyone who has been convicted of a wildlife crime then has to apply individually for a licence to do anything that they want to do. I quite like that model. It's quite a nice, progressive sort of way of looking at the world. So I think there are places for these things to work.
I also wonder.
I have an issue with general licences, which I think you know about. So, but
They
yeah.
are not legal.
I'm not sure I agree with this statement I'm about to make.
Okay.
I wonder if there's a place for wildlife legislation that controls these behaviours, that tend to be all the sorts of behaviours that you're concerned with and involve licensing, that uses regulation, uses administrative sanctions, but also has the final remit of criminalisation if necessary, the final sort of stick, and then an understanding of violent crime as being something that can be perpetrated against an animal victim as something that's different. So we apply our interpretations of violent crime extend to giving victimhood to animals, and that animals can therefore suffer as victims of violent crime.
There's a problem.
I don't think it works, but
I mean, there's a problem. I promised not to mention badgers, and here I'm mentioning them for the second time too. That's really bad. But if you license something like culling badgers, and what we saw last autumn around the cull areas was a certain amount of illegal activity associated with it. People think they can get away with it because they see it's been kind of legitimised or whatever. But what you're saying is that one of the culling companies that goes and shoots a badger that's 150 yards outside of the zone which they are allowed to operate might be treated differently than if the farmer who owned that field went out and shot that same badger, because he's not licensed to do the activity within the licensed area. But the impact is the same on the victim. Of course, we don't have victims either, but on the badger, which doesn't seem very logical. So if the license holder who's gone beyond the conditions of the license is treated differently than the farmer who doesn't have the license in the first place, then it doesn't seem sort of proportionate.
We did wonder about some part of this, and we didn't explore this any further, but I'll put it forward and then you can shoot it down, because we sort of looked at it and then realised we couldn't separate it. In a way, you can understand slightly more civil sanctions rule if the underlying thing that you're doing is for conservation. If you see it solely as being regulation of the environment, where it's a number, I care about the number of X hen harriers or something like that, then that actually you can see that model falling into the criminal law's backstop. But before that, I'm going to warnings and sanctions, fines and enforcement undertakings. If you replace the newts that you killed with new newts, then we're all fine. Everything theoretically may or may not look approximately how we want it to. Whereas welfare is almost wholly unacceptable for the world of civil sanctions, because it's not really dealing with that. It is your crime of violence, for instance. The downside of this is that the singular offence, killing the bird, handles both of those two aspects, and we couldn't work out how to pair them out. It is actually a flaw, unfortunately. We really did, because we can see, obviously it's theological, but it's still the single dead. I will pick a different species this time. This one is a dormouse, also cute, but so it is quite a problem where you can see that the moral value in the law is very different in those two aspects.
And in relation to companion animals, there is, and it's getting slightly off topic, but there are models that actually see the animal almost, if you like, as a victim. And so certainly the Animal Welfare Act, which introduces this duty of care for welfare, and says you have to look at the individual animal and not treat all cats the same, because some are indoor. I'm not making this up, but it actually says you have to look at the individual animal and its individual needs, and you have offences related to not looking at what that individual animal needs, whether or not the courts will look at how those codes work in practice. I'm guessing the same is true in the primates kept for the needs of pets, but you know what I mean, domesticated primates code. So there's that. And then there are some American states that have introduced sort of animal abuse registers in the same way that you have sex offender registers, so they treat it specifically as a sort of victimhood thing. It's a very small number of American states. So that happens. Is there a question? Otherwise I'm going to ask one final. No? Yeah. Sorry, I feel like I bullied you into that.
I formulated this quite pointedly,
Okay.
but under all the discussions and everything, I see about regulations and native wildlife and welfare issues, but what's falling through the gaps, so to speak, is the international aspect, the illegal wildlife trade aspect. So the example that Mark put up about the ivory being sold on the internet, and the fact that that kind of wildlife crime, whether I don't know if that's under the wildlife crime bracket that we're talking about right now, but that kind of wildlife crime is definitely connected to serious and organised crime, human trafficking, and criminal offences that are definitely seen as something that should be important to us all. So I'm just wondering where that kind of fits in the discussions that we've been having.
And I think when you raise offences like that, it's much harder for people to argue against it being the police or border agency that ought to be investigating it. Because it much more quite clearly falls into our understanding of traditional crime and the sorts of things that the police should be dealing with.
And by bringing in the transnational element, you also mentioned you bring in the seriousness, and you absolutely don't want to, nobody wants to be seen to not be taking transnational crime seriously. Is it covered by the Commission's proposals, I think is the underlying question?
No. It's not, or CITES isn't. Because there's not a lot we can do to it. It's covered by 2 utterly blockbuster EU regulations, so it's not open for review. There's nothing, we can't touch it, we can't spell it out, we pretty much can't even mention them. You can apply a sanctioning regime in the UK, which is what we do through COTIS. COTIS theoretically is up for review anyway, although I have been giving them, as I said, although it is theoretically up for review, although I have heard that for a bit, in the same way we might be getting an environmental court. There's lots of things which might, but it's not really in our gift. So all you need to do at that point is have something which is sufficiently effective and dissuasive to make good the European obligation, and that's something which the state will have to do.
Okay. Right, I'm going to ask one final question before we wrap up, and it is this. I've forgotten the colourful metaphor that Haydn used, but do we think the Commission's proposals will actually get through in the current Parliament?
No, to that one. Because the date for the current...
I don't.
Well, the date for the current Parliament is tomorrow, maybe?
No, it means before the general election.
Yeah, but that's it. But yes, but that's where the final session
There's
starts.
a specific
The
date.
final session starts with the Queen's speech. The Queen's speech will be in June.
Yeah.
And everything for that should be written and lodged by now. We haven't published, so therefore it cannot and will not be in the current Parliament.
That's
Now-
the definitive statement I was looking for. Thank you.
There is a second question.
The second question is what happens after the election?
But when, and your election where? Wales runs at a slightly different timetable.
True.
To the UK Parliament. And
There's only one of many differences between UK and Wales.
Let's not go there.
That's very, yeah.
And it's a year later, and it's not a guarantee that it might not come early in Wales as opposed to. We don't know. They're kind of busy at the moment.
Wales got its hands exceptionally full with those 3 bills.
Yeah.
I mean, this is breaking new ground there. It's possible, but not likely.
Yeah. So we're looking at after the election and something happening then.
Yes. I think that's probably true for both places.
I think,
Although I think there's more commitment in Wales.
Is there a fixed timetable for DEFRA to consider the Law Commission's
Yes,
proposals?
6 months in 1 year. They have to give an interim response within 6 months, and they have to give a full response for within a year of us publishing, of the Law Commission publishing. The Law Commission will publish probably September, October this year, I would have thought.
So it's going to be sort of April, which will be the...
Yeah, perfectly timed.
Yeah.
I think.
Yes. What I was trying to get them to say was that this is likely to be a sort of a hot issue come the election. particularly for NGOs wanting to test the environmental credentials of, oh, I don't know, let's say UKIP off the top of my head. Yeah, but, so is that one last, yeah?
I have a question. Well, instead of the low sanctions that the panel is just saying, we won't be better to look for human law in order to change human behaviors, especially the cultural ones that sometimes people can kill animals, or also because of health problems, mental health problems. Because what I'm seeing is that there is all the topics are more focused about laws of sanctions, about the issue, the behavior, why a human kill an animal.
So are you asking whether we should be trying to make the law change human behaviour so that animals...
Looking more in relation to law than sanctions about the behavior. Because if we are looking just only for sanctions, people are going to continue killing. So if we go for the main point, the basics, we have made changes.
I've already been told it falls on my shoulders as the criminologist to answer this question. I don't know the answer to this question, but what I would say is if that's an area that we need to be looking at in relation to this, then it requires criminologists, sociologists and psychologists to be more interested in this field as a starting point. And then in terms of sanctions, if you're looking at prevention, we want to do primary and secondary prevention, which is identifying people who, for example, secondary prevention is about identifying people who are at risk of committing crime but haven't yet committed crime. That generally tends to be young people that might get flagged up in schools and so forth, are demonstrating certain what we would think of as riskier antisocial behaviours, and then trying to intervene with them in some way to sort of change whatever it might be that might cause them to be criminal. And what we do about that is extremely contentious within criminology and the associated fields, and wouldn't even hesitate to try and even go there yet. But that is one that I think that's really kind of what you're getting at is in terms of trying to change behaviour and prevent behaviour. It's not something you do with law, it's not something you do with criminal legislation. It's unlikely to be something that you're going to do after the fact of catching people, although there may be some rehabilitative sentencing that could be used with certain types of individual for certain types of crime. But again, that is sort of things like about education in schools and awareness raising and informal social control and all of that kind of stuff, which is not something that's going to be affected by whatever we do in terms of criminal legislation.
But legislation has an educational value.
It does, yeah. And therefore having criminal legislation, again, it underpins that moralising effect, informal social control. It can be the prompt that makes us do public awareness, education and that kind of thing. Whether that's enough for us to justify it is another question.
Always nice to finish on an easy question to answer. Okay, I will call it to a halt there and say thank you all for coming. If we could thank all our speakers, our panel, for their and you will have noticed that we've been filming today. We hope to edit this down into a manageable chunk, and we also hope to write something that is a sort of proceedings, if you like, from here, which we will circulate to everybody once we've got that done. I do not expect that will be quick, but we will get that done as soon as we possibly can. And obviously, our school and colleagues here as well, we'll probably be doing further work on wildlife reform, particularly in the run-up to the election. I expect Mark to be particularly active, both in the run-up to the election and after.
So anything political.
And also in terms of hopefully doing some policy work on what will happen if the Commission's proposals are either accepted or not accepted. So watch this space and keep in touch. And thanks for coming.